Hello, hello, hello. Good evening, everybody. Just let me know quickly if I am properly visible and audible to all of you so that we can start our today's revision. Good evening, Tushar, Khushi, Shikha, Jethalal, Aman, Palak, Pabak. Good evening, everybody. Good evening. Very good evening to all of you. Okay. How are you all? Let me quickly share the link of the class in all the groups. We'll just start in 2 minutes. पीछे से वॉइस बहुत आ रही है, बैकग्राउंड नॉइज आ रही है. हाउ इज इट नाउ? कूलर नहीं है, फैन की आवाज़ है वो. हाउ इज इट नाउ? इज इट ओके नाउ? अब ठीक है क्या? आ रही है बट चलेगा. ओके. बहुत ज़्यादा आ रही है, मैं सुन के देखूं क्या? एक्चुअल में आ रही है. हेलो. अब ठीक है क्या? हाउ इज इट नाउ? अब ठीक है क्या? अब अब ठीक है. अब ठीक है. हेलो. अब ठीक है क्या? हाउ इज इट नाउ? अब ठीक है शायद. Great. So a lot of people have joined. So we are good to start with our today's lecture. I guess the voice is fine now. All right. Great, great, great. So share the link of the class to all your friends and in all the groups so that everybody can join and we can start our today's director revision, which is very, 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 very important. जेठालाल मैम सेटअप टूर वीडियो आराम से रिवीजन कंप्लीट हो जाने दो, उसके बाद आराम से करेंगे. ओके. हाँ जी, नोट्स कल ही अपलोड हो गए थे. नोट्स yesterday notes were uploaded already. Okay. So yesterday we completed with a lot of sections of this chapter. Let's start our today's revision. Let's start finally our today's revision. Okay. So people, yesterday we completed our section 149, 150, 151, 152, 153 to 159, which talks about din. After that, we did 161. All these sections were completed yesterday. Today, we will be covering 160, 162, 163, 164, and so on till 172. So today, we'll complete this, and after that, we'll start our board meeting. So just let me know quickly in the chat box, how's the Josh? Give me a big fat thumbs up in the chat box and to the video so that we'll start our today's revision series. Always high. Great. Great. Okay. People, notes were uploaded yesterday in the app. So today we will be doing section 160. Yesterday we studied section 152, and in section 152 we studied that there is a concept of rotational director. In section 152 we studied that there is a concept of rotational director which says that in the AGM at least 2/3 of the total director will be rotational director, which means they will retire, and in place of the retired director we will appoint new director. Okay, so we have studied the concept of rotational director, that at least 2/3 of the total director will be rotational director who will retire, and I've also taught you that this concept of rotation is only applicable to public company and not private company, sir. So and what we do, there are 2/3 of the total director as a rotational director, and at AGM 1/3 of this rotational director retire, and when the rotational director retire at AGM we fill up this casual vacancy by either reappointing the retired director or by appointing any other person in place of the retiring director, or by filing a resolution to not to fill vacancy. This we studied. Yes ma'am. Now we will study a concept, section 160, which talks about right of person other than retiring director to stand for directorship. Please understand carefully that sometimes you want to appoint a person as the director who's not a retiring director, or sometimes you want to appoint a person as a director in place of any other director who's not a retiring director. कहने की बात समझो एकदम, मैं आपको हिंदी में एक सिंपल शब्दों में बताती हूँ. अगर कोई डायरेक्टर रिटायर हो रहा है उसके बदले आप किसी को अपॉइंट कर रहे हो तो वो हो जाएगा कि आप रिटायरिंग डायरेक्टर के बदले किसी को अपॉइंट कर रहे हो, और वो एक ऑर्डिनरी बिजनेस है जो अपन ने अड्डा में पढ़ा था, अपॉइंटमेंट ऑफ डायरेक्टर इन प्लेस ऑफ रिटायरिंग डायरेक्टर। बट यहाँ पर बोल रहा है कि जब आप किसी और पर्सन को अपॉइंट करते हो ऐसे ही कैजुअली, रिटायरिंग डायरेक्टर के बदले नहीं, और नॉट एज अ रिटायरिंग डायरेक्टर, then that person can be appointed as per this section. So here simply one point is given, that simply one point is given that a person, if you want to appoint a person who is not a retiring director, then this section will be applied, section 160. And you know what, let's say in our company, in edu mention private company, we want to appoint, let's say, Salman Khan as the director. So we will propose Salman Khan to make him the director of the company. What we have to do, we have to give a notice to the company that company, we want to appoint Salman Khan as the director. And along with that, if we are introducing some new face, if we are saying Salman Khan, अभी तक उसका कोई लेना देना नहीं है, till now Salman Khan is not a director, he is a new person. Till now Salman Khan is not a retiring director, rotation director, he is a new person, and we want to appoint him in the directorship. Then we will say first deposit some money, so we will ask them to deposit 1 lakh rupees money, and then only voting will be done, and if OR is passed, then he will be appointed. Obviously not, I told you that who is the appointing authority of the director? Members are the appointing authority. So members will appoint the director by passing ordinary resolution. Members will appoint the director by passing the ordinary resolution. So here simply there is a one concept. Let's say we have a company, and in our company I want to appoint Salman Khan as the director, who is not a retiring director. And we are appointing Salman Khan casually, not in place of the retiring director. So it's like, let's say, ordinary director. So we want to appoint Salman Khan. So we are the members, and if we want to appoint Salman Khan as the director of the company, we have to follow the procedure mentioned in section 160. And what is this procedure says? This procedure says that if you are proposing the name of Salman Khan to be appointed as a director, you have to give a notice in writing to the company. That notice should be in writing, and that should signify, means tell about the candidature. Candidature means the person who's the candidate. So we have to just write the notice that we want to appoint Salman Khan as the director. We have to make this notice, and we have to deliver this notice to the company. Along with that, we have to give money, apna sapna money. So along with that, we have to submit money, that is 1 lakh rupees deposit to the company. How many days? At least 14 days before the meeting, be it AGM, be it EOGM. Now let's say Salman Khan is saying, I want to become the director of the company. Salman Khan is himself want to make an application to the company. Members are not proposing his name. Salman Khan is coming himself कि मेरे को डायरेक्टर बनने का है. तो यू नो दिस पर्सन कैन ऑल्सो गिव अ नोटिस टू द कंपनी दैट आई वांट टू बिकम द डायरेक्टर, आई वांट टू स्टैंड फॉर द कैंडिडेचर, आई वांट टू बिकम द डायरेक्टर. सो दिस पर्सन कैन ऑल्सो मेक अ नोटिस इन राइटिंग to the company signifying that I want to become the director, I want to stand for the candidature. And in both the cases, if he is saying I want to become the director, I want to become the director, he has to give notice in writing to the company, and also he has to deposit 1 lakh rupees money at least 14 days before the meeting. Now what will be held in the company will inform all the members that this Salman Khan is proposed to be appointed as a director, and at the meeting resolution will be passed, resolution will be put to vote, voting will be done. Either resolution will pass or resolution will fail. So there is one concept that this people will give a notice to the company that we want to appoint Salman Khan as the director, and then company will inform all the members that सुनो Salman Khan को director appoint करना है. So company will inform all the members. Either if there is sufficient time, we can give individual notice, सबके घर पहुंचा देंगे, and if there is no sufficient time, then instead of giving the individual notice, we can make government Indora 2 newspaper publication, one in English, one in vernacular, having circulation in the district where the registered office of the company is situated. Very clear? Okay, then company will inform all the member either through individual notice or through two newspaper. Now at the meeting, voting will be done. Either he will pass, either पप्पू पास हो जाएगा या तो पप्पू फेल हो जाएगा. So either he will pass, either he will be appointed, or the resolution will fail. If he will not get more than 50% vote, right? So if the resolution get passed, which means पप्पू पास हो गया, पप्पू की फीस रिफंड हो जाएगी. So if the resolution passed, that means Salman Khan gets appointed, we will refund his 1 lakh deposit. Okay, you appointed, now you can take this deposit. It's like a security deposit. And if the resolution fails, then we will see kitna vote mila. If he will get 25% or more than 25% votes in favor, in that case, sorry, if he gets more than 25% votes in favor, in that case we will say यार 25% ज्यादा वोट मिला था, थोड़ा सा और 20% 25% वोट और मिल जाता ना, पास हो जाता. So in that case, if he gets 25 more than 25% votes, again in that case also we will refund his money. However, if he gets less than or up to 25% votes only and not more than 25%, then we will say खुद का तो टाइम वेस्ट किया, मेंबर्स का भी टाइम वेस्ट किया. Time based. Not even he didn't even get more than 25% votes in the favor. So in that case we will forfeit his 1 lakh rupees deposit. खा जाएगी company उसको. So are you getting this point? This is section 160, that whenever you want to appoint a person who's other than retiring director, then either member can propose his name, or the proposed director can himself propose his name by giving a notice in writing to the company along with 1 lakh rupees deposit at least 14 days before the meeting. And what company will do? Company will inform all the member either individually or by newspaper advertisement. Done. After that, meeting will be held, voting will be done. If he get appointed, very good, you didn't wasted our time, we will refund the 1 lakh rupees money. If he didn't get appointed, if the resolution fails, then also if he gets more than 25% vote, अच्छा खासा वोट मिला था, then we will refund his money. But if he gets only up to 25% votes and not more than 25% vote, we will say कि वो सबका टाइम वेस्ट करके चला गया, will forfeit all his money, all his 1 lakh rupees deposit will be forfeited. And you know what, this 1 lakh rupees deposit is not required in case of if you are proposing to appoint independent director, if you are appointing a director who is recommended by NRC. NRC means we will study. NRC is a committee, nomination and remuneration committee. The duty of this committee is to recommend the director, is to recommend whom to be appointed, who should be appointed as the director. So if that director is proposed by NRC, then 1 lakh rupees deposit is not required. हम सोचेंगे कि NRC ने propose किया, अच्छा ही होगा. Next is, in case company does not have NRC, then it's the duty of board to recommend that appointment. And if in case the board have recommended, that director, then in that case 1 lakh rupees deposit will not be needed. So 1 lakh rupees deposit will not be needed if you are appointing independent director. Number 2, director appointed by NRC. However, if there is no NRC in the company, then director recommended by board. Number 1, independent director. Number 2, director recommended by NRC. अगर NRC ने recommend किया तो अच्छा ही होगा, deposit लेने की जरूरत नहीं है. So if he is recommended by NRC, then no need of deposit. However, if there is no NRC, then it's the duty of board to recommend. And in that case, if that director is recommended by board, then 1 lakh rupees deposit will not be needed. Next is section 160 is not applicable to some companies. प्राइवेट कंपनी. अब प्राइवेट कंपनी में मान के चलो मेरे को मेरे भाई को डायरेक्टर बनाने का है, मैं क्या 1 लाख रुपए दूंगी? नहीं ना. इन प्राइवेट कंपनी इट्स योर विश, आपको जिसको डायरेक्टर बनाने बनाओ. इन प्राइवेट कंपनी मोस्टली देयर आर स्मॉल फैमिली कंपनीज. इन केस ऑफ प्राइवेट कंपनी you can appoint anybody as a director. You don't need to follow this procedure. You don't need to give all shareholders notice. You don't need to give 14 days notice. You don't need to give 1 lakh rupees deposit. So section 160 is not applicable to private company, which means that section 160 is applicable only to public company. And you know what, section 160 is also not applicable to such a government company which is 100% held by government. Means such a government company in which 100% money is invested by central government or state government, which means that such a government company in which 100% shares are held by central or state government or subsidiary of such government company. Next, section 8 company, if the article provides for election of director by ballot, and if section 8 company has written that no, we will appoint a director by ballot and we will not follow this procedure of 160, In that case, 160 will not be applicable to this kind of company. So I hope this process of 160 is very clear to you all. Up, I am going to tell you a very important case law in this. Very important case law in this. There was a person. His name is Pappu. There was a person, his name is Pappu, and Pappu was the additional director of XYZ Limited. Pappu is the additional director of XYZ Limited. Now we want to appoint him as a normal director. Additional director is the temporary director na, appointed by board. We want to appoint as a normal director. So we called EOGM. And in that EOGM we appointed we in that EOGM, we want to appoint Pappu as director. In that EOGM, we want to appoint Pappu as director. This is a public company. Please let me know whether we have to follow 160 or not. Whether we have to follow 160 or not. Whether we have to follow section 160 or not. अरे बेटा जी, ओ बेटा जी, here you have to follow section 150. क्यों? क्योंकि आप एडिशनल डायरेक्टर के बदले अपॉइंट कर रहे हो. ही इज नॉट रिटायरिंग डायरेक्टर. रिटायरिंग डायरेक्टर नॉर्मल जो एजीएम में अपॉइंट होता है और जो एजीएम में ही उसके बदले अपॉइंट करते हैं वो होता है रिटायरिंग डायरेक्टर. इसीलिए आई रिवाइज सेक्शन 152. दिस एडिशनल डायरेक्टर इज नॉट रिटायरिंग डायरेक्टर एंड यू आर अपॉइंटिंग पप्पू who is not a retiring director. So that is why here this will not come under section 152. This will come under section 162. It will come here. 160, sorry, section 160. Are you getting this point? That whenever you want to appoint a person as a director who is other than retiring director, then this section will be applicable. And again, you know what? This is not OR. This is not OR. This is SR. I'm really sorry. This is not OB. This is SB. What does this mean? This means that, you know what? This is not ordinary business. This is a special business. Remember, we studied ordinary business. Remember, we studied ordinary business. Ordinary business was Adda. Remember, I have taught you ordinary business in section 102. I have taught you what do you mean by ordinary business in section 102. Ordinary business means Adda. Ordinary business means there was a point ADDA. There was a point appointment of director in place of retiring director. Appointment of director in place of retiring director. There was a provision appointment of director in place of retiring director is the ordinary business. So that was ordinary business. But here when you are appointing a person other than retiring director, this is not ordinary business. This is a special business, which means in order to appoint any person as the director, if at any point of time you want to appoint any person as the director, then this is a special business, and this can be done through AGM as well, and this can be done through EOGM as well. This can be done through both AGM as well as EOGM. Are you getting this point? इतना एनालिसिस आपको कहीं नहीं मिलेगा. प्लस इससे आपको केस लॉ क्वेश्चन आ सकते हैं. यू हैव टू अंडरस्टैंड दिस. व्हाई? बिकॉज यू विल नॉट सी डायरेक्ट क्वेश्चन इन योर कंपनी लॉ पेपर अनलाइक योर JIGL or SBC. So here there will be case law question. 95% question will be case law question. So you have to understand this, that if you want to appoint a person other than retiring director, so this is not an ordinary business. That ordinary business was different. Appointing a director in place of retiring director, that was different. Okay, so that was different. And this, if you want to appoint a person in place of any other director, who's not a retiring director, then you have to follow this section 160. You have to follow this procedure, and you know what, you can appoint this director either at EOGM और at AGM. ऐसा AGM में अपॉइंट करना जरूरी नहीं है, आप EOGM में भी अपॉइंट कर सकते हो, AGM में भी अपॉइंट कर सकते हो. You can appoint in any of the general meeting, either EOGM or AGM. I hope you are crystal clear with this point. That's why if you are appointing Pappu in place of additional director, then here this is not ordinary business, this is not a DAF, first point. Secondly, here you have to follow this section 160. Here you have to follow this procedure of 160, and you have to give this 14 days notice, and then you have to give this 1 lakh rupees deposit. All this procedure of section 160 you have to follow. I hope you are crystal clear with this. एकदम लास्ट में फिर से बोल रही हूँ, अगर आप रिटायरिंग डायरेक्टर के बदले किसी और को अपॉइंट करते हो तो वो ऑर्डिनरी बिजनेस होता है, वो फिर एजीएम में ही कर सकते हैं सिर्फ. लेकिन जब आप किसी और डायरेक्टर के बदले किसी डायरेक्टर को अपॉइंट करते हो तो वो ऑर्डिनरी बिजनेस नहीं है, और उसको आप एजीएम में भी कर सकते हो, ईओजीएम में भी कर सकते हो, और उस केस में फिर आपको 160 फॉलो करना पड़ता है. समझ में आया? वन सिंगल लाइन. 162. Appointment of director to be voted individually. Appointment of director to be voted individually. What does this mean, sir? This means that, let's say I want to appoint 2 directors. There are 2 vacancies. We want to appoint 2 directors, and there is seat number 1 and seat number 2. We want to appoint 2 directors. In this, we want to appoint Khushi as the director, and this we want to appoint Palak as the director. Then madam, then you know what, there is a point that by single resolution, like आप single resolution pass करके 2 लोगों को appoint नहीं कर सकते. By passing single resolution, that means by passing single OR, you cannot appoint 2 person as a director. You have to pass different resolution, separate resolution. Like first, for Khushi, for appointment of Khushi as the director, you have to do separate voting. Okay, who are saying yes, who are saying no. So you have to do separate voting. You have to pass OR separately. And then for appointing Palak as the director, you again have to do the voting. You again have to pass the ordinary resolution. You cannot appoint 2 director or more than 2 director by single OR, by single resolution. This is given in section 162, which says that single resolution, single OR shall not be moved, shall not be passed, should not be passed for appointment of multiple director. Is it never possible? No, वैसे तो never possible, but there is one exception. In one situation it may be possible. If all the members first agree to it without any votes against it. Like before appointing, if we want to appoint Khushi and Palak by single OR, then first we have to take approval of all the shareholders. So first in the meeting, we will ask every shareholder. Let's say here we have 20 shareholders. Let's say we have 20 shareholders. I will ask all the 20 shareholders that can we pass a single OR for appointment of both Khushi and Palak? And if all of you will say yes, or let's say nobody is saying against it, nobody is saying no. Like among these 20 people, 16 people has said yes, okay, we can pass a single resolution. And 4 people were silent, 4 people were chup, 4 people were Manmohan Singh. So 4 people were silent, they didn't say anything. Which means that, is the approval done? Yes. I got approval of all the shareholder. Here, no shareholder is, against it. No one is against it. Everybody is saying yes. Either they are silent or they are saying yes. Means nobody is against it. Which means I got the approval of all the shareholders. I got the approval of all shareholders. Now I can pass a single OR for the appointment of Khushi and Palak. Are you getting this point? That वैसे तो it's not allowed. वैसे तो normally it's not allowed to pass a single resolution for appointment of multiple director. But you can pass a single resolution if it is first agreed by all the members without any votes against it. If it is first agreed by members without any votes against it, which means first we have to do a separate voting. Can we pass a single resolution? You have to get approval for that, and that should not be against. No shareholder should be against it. कोई मना नहीं करना चाहिए. अगर चुप रहेंगे तो चलेगा. If they are silent, it's okay. They should not say no to it. And if everybody has said yes, or nobody has said no, then now we can pass a single resolution for the appointment of multiple directors. So this is the point, section 162. And there's one very not so important point, that this 160 is not applicable to government company where 100% shares are held by central or state government and subsidy of such government company. So this is the small section, section 162. वन 163 लास्ट में करेंगे. 164, disqualification of director, very important section. Now we are starting with a very important section series. Section 164, very important. Section 164, disqualification of director, and this disqualification is divided in two parts, subsection 1 and subsection 2. There is subsection 1 of the disqualification of director, that when a person will be disqualified to become the director. Number 1, if वो पगला है, if he is unsound mind means lunatic. Okay, if he is of unsound mind. Next is if he is undischarged insolvent. भैया दिवालिया निकल गया उसका. He is undischarged insolvent means he is insolvent declared by the court, declared by the competent authority. He is undischarged insolvent. Or number 3, he is not able to pay its debt. So he has applied to the court for being declared as the insolvent, but that application is still pending. He is not yet declared as insolvent. So here one point is given. What point is given, ma'am? The point is given that if you are not yet declared as insolvent by the court, but you have made application to be declared as insolvent and that application is pending, even then also you are disqualified to become the director. If you have applied to the court or the competent authority for being adjudicated as insolvent and that application is pending. Number 4, sir, offense किया आपने, you convicted for offense for 6 months or more, आपको जेल हो गई, you are imprisonment, you are behind the bars, you are imprisonment for a period of minimum 6 months, which means you are imprisonment for a 6 months or more, then you know what, you will be disqualified for 5 years from the end of conviction. End of conviction मतलब जिस दिन आप जेल से बाहर निकलोगे उसके 5 साल के लिए डिस्क्वालीफाई हो जाओगे. End of conviction means the day when your jail will over, when your imprisonment will over. After that you will be disqualified for the 5 year. And you know what, if you are convicted for 7 year or more, 7 साल की सजा हो गई, तो you will be disqualified for lifetime. आपको if you are convicted for 7 years, then you will be disqualified for your lifetime. Next is if you are disqualified by court or NCLT order. Sometime if you are a defaulter person, if you have done any fraud, money laundering, etc., then you know court NCLT pass order and disqualify you. So you will be disqualified even if an order is passed by the court or NCLT. Next is convicted under 188. 188, very important section. We will study day after tomorrow. 188 means related party transactions. RPT. If you have defaulted in related party transaction, bro, you have done some jhol, you have done some fraud. If you have defaulted in 188, if you have defaulted in related party transaction and you are convicted under that, आपको जेल हो गई है, you are imprisonment. If you are imprisoned under section 188, then you will be disqualified to become the director. Next is you have not paid the call money. If you are also holding the shares of the company and you are not paying the call money, company is asking you money, bro, pay your share money, bro, pay your call money, and you are not paying it, and this default continued for 6 months or more, then you will be disqualified to become the director, which means you defaulted in payment for 6 months or more. You defaulted in payment for 6 months or more. Next is maximum directorship under section 165. I have not taught you 165. We'll study 165 after this, which says that if I want to become director in, let's say, 10 companies, can I become? Yes. So there is a limit given that I can be appointed as a director in maximum 20 companies. There is a limit given that I can appoint as a director in X Limited, Y Limited, Z Limited, A Limited, B Limited, C Limited. I can be appointed as a director of maximum 20 companies. And if that is the limit, and in case I don't comply with that, in case I get appointed as the director of more than 20 companies, in that case I will be disqualified to become the director, which means that I did not comply with section 165, then I will be disqualified to become the director. Next is no DIN. In order to become the director, you must have DIN. आपके पास DIN नहीं है तो आप डायरेक्टर नहीं बन सकते, which means that if you don't have DIN, you can't be appointed as director. And sometimes if you do default, central government cancels your DIN. So if your DIN is cancelled by the central government, then also you will be disqualified to become the director. So are you getting this point? What are the disqualification of director? मैम समझ में तो आ गया, याद कैसे करें, how to remember? So these 3 points are similar to each other. Unsound mind, insolvent, applied for insolvent. Okay, link this. Trust me, एक भी point नहीं भूलोगे, जैसे बता रही हूँ वैसे पढ़ो. You will not forget even a single point. 3 points are related to each other. Unsound mind, if you are undischarged insolvent, you have applied to be adjudicated and insolvent, but it is pending. तो एक unsound mind वाला, 2 insolvent वाला point है. After that, next 3 points are related to each other. Convicted, convicted, convicted. Basically, you have done offense. You have done offense and convicted for 6 months or more. ये वाला point. Next is convicted and by NCLT order, disqualified by NCLT court order. Court, यहाँ भी court है. And third is convicted by court under 188. So ये तीनों default वाला point है कि आपने कुछ default किया. So these 3 points are similar, related to offense and default. Number 1, you have done normal offense. Number 2, court has disqualified you. And number 3, you have disqualified under 188. You have defaulted in section 188. You are convicted under section 188. So these 3 points are related to each other. After that, there are 3 extra points. Number 1, एक पैसा नहीं दिया, ठीक है, 20 से ज्यादा कंपनी में डायरेक्टर पॉइंट हो गए, नो डिन, नो डिन. सो दिस 3 points are extra. So how you will remember this disqualification? 3 plus 3 plus 3. Okay, 3 plus 3 plus 3. 3 points were related to each other. Unsound mind, undischarged insolvent, applied for insolvent. Next 3 point, okay, court wala. Convicted by court for offense for 6 months or more, then you will be disqualified for 5 years from the end of conviction. And if you are convicted for 7 years or more, then you will be disqualified for lifetime. Next is you are disqualified by court or order, court or NCLT order. Next is you are convicted under 188, related party transaction. उसके बाद के 3 point, you have not paid the call money for 6 months or more. You have accepted the directorship beyond the maximum directorship mentioned under 165. And next is no din, no din. नो डेन. आई होप आपको ये 9 के 9 पॉइंट्स याद हो गए हैं. यूजुअली इसको याद कर लो अभी के अभी, क्योंकि 177 167 में सिमिलर पॉइंट्स हैं. सो डू रिमेंबर ऑल दिस 9 पॉइंट्स राइट नाउ. व्हाई? बिकॉज इन 177 167 देयर आर सिमिलर पॉइंट्स, सो दैट खिचड़ी ना पके. You will remember it properly. Just go through this, all the 9 points. Go through all the 9 points. Now, madam, there is one small point that, madam, अगर हमें कोर्ट, अगर हमने कोर्ट ने ऑर्डर पास करके डिफॉल्ट कर दिया, कोर्ट ने जेल दे दिया, तो फिर क्या हम तुरंत डिस्क्वालीफाई हो जाएंगे? क्या हम अपील फाइल कर सकते हैं? यस, ऑब्वियसली यू कैन फाइल अपील. इफ कोर्ट हैज कन्विक्टेड यू अंडर सेक्शन दिस एंड दिस, if you are convicted by court, if you are convicted by court under this and this 3 points, under this 3 point 4 5 and 6, if you are convicted by court under this 3 point, can you file an appeal? Yes, you can file an appeal definitely to the higher authority. But does it mean you will not be disqualified? नहीं, you will still be disqualified. तो भले आपने उस कोर्ट के ऑर्डर के अगेंस्ट अपील फाइल किया, लेकिन फिर भी आप डिस्क्वालिफाइड माने जाओगे. सो हियर वन पॉइंट इज गिवन, डजंट मैटर इफ यू हैव फाइल्ड अपील और नॉट, you will still be disqualified. So here one point is given that in these 3 cases you will be disqualified even if you have filed appeal against the order of court or tribunal. I hope this point is clear to you all, that in these 3 cases you will be disqualified even if the appeal is filed against the order of court or tribunal. You will be disqualified even if the appeal is filed against the order of court or tribunal. भले आपने हायर कोर्ट में, लाइक हाई कोर्ट का अपील सुप्रीम कोर्ट में फाइल कर दिया, फिर भी आप डिस्क्वालिफाइड हो जाओगे. You will still be disqualified. I hope this point is crystal clear to all of you. Now there is a second subsection, there is another disqualification under section 164 subsection 2, which says that basically if a company fails to file the 2 most important document of the company, which means that if a company fails to file financial statement or annual return, that is AOC 4 and MGT 7, if a company fails to file AOC 4 and MGT 7 for 3 consecutive years, There is a doubt, what if you succeed in appeal? If you succeed in appeal, then your disqualification will be removed, which means you are not convicted now. You are not convicted. If you succeed in appeal, then it's okay. But there is one point next, that if a company fails to file the financial statement or annual return, which is basically AOC 4 and MGT 7, and if a company fails to file these three documents for the continuous period of 3 years, continuous 3 years, then all the director of that company will be disqualified to be reappointed in the same company or appointed in any other company for a period of 5 years. 5 साल के लिए disqualify हो जाएंगे for 5 years. And also, if a company fails to pay deposit or interest, debenture and interest or dividend for a continuous period of 1 year. Are you getting this point? That if a company fails to file financial statement or annual return for a continuous period of 3 years, or a company fails to pay deposit or interest, debenture or interest or dividend for a continuous period of 1 year, then all the directors of this particular company will be disqualified to be reappointed in the same company and appointed in any other company for a period of 5 years. अब इसको मैं एग्जाम्पल के साथ समझाती हूँ आपको. What happens, you and you are director in XYZ Limited, and this company XYZ Limited failed to file AOC 4, failed to file AOC 4 or MGT 7 for 3 years, for continuous 3 years, या फिर this company failed to pay the deposit interest, dividend interest or dividend or debenture interest in for 1 continuous year, then you know what, all these director, let's say Mr. X, Mr. Y and Mr. Z, all these 3 director will be disqualified. All these 3 director will be disqualified. To what? To get reappointed in this company and appointed in any other company, which means that ये लोग इस कंपनी में तुरंत छोड़ के नहीं जाएंगे. इस कंपनी में ये लोग रीअपॉइंट नहीं हो पाएंगे. रीअपॉइंट होने के लिए डिस्क्वालीफाई हो जाएंगे, which means that they will be disqualified to get reappointed. तो करंट टर्म जब तक चल रहा है वो चलेगा इनका. करंट टर्म विल गो. After that, present term will expire. After that, they will not be able to get reappointed in that company. And however, let's say now another company is asking them, there is another company ABC Limited. This company is saying to Mr. X, I want to appoint you as the director. Can this company ABC Limited appoint Mr. X as the director? The answer is no. Why? Because he is disqualified to get reappointed in XYZ Limited and appointed in any other company. Are you getting this point? ये point बहुत important है कि आप disqualify क्या चीज के लिए हो रहा है. You are getting disqualified to get reappointed in the same company. Same company means the company which made default, which means the company which made default XYZ Limited. And if you are the director of that XYZ Limited, you will continue to be the director of XYZ Limited for your present term. And once your present term will expire, after that you will not be eligible for reappointment. After that you will get disqualified for reappointment in that same company or appointment in any other company. Are you getting this point? So, if there is any company which fails to file financial statement or annual return for a continuous period of 3 years, or you are a company who fails to pay the deposit or interest or debenture interest or dividend for a continuous period of 1 year, then all the director of this defaulting company will be disqualified to get reappointed in the same company or appointed in any other company for 5 years. Subsection 2 में default सिर्फ 5 साल का है, only for 5 years. And there is one point given that this default, no disqualification under section 164 subsection 2 for 6 months from the appointment. If you are new director, you are recently appointed in that company और बाद में आपको पता चला अरे ये तो डिफॉल्टर कंपनी है, अरे इसे तो 3 साल से फाइल नहीं किया है. So if you are a new director appointed in that company, for 6 months you will not incur any disqualification. आप ये बोल सकते हो अरे मैं तो ये अभी आया हूँ, मुझे तो पता ही नहीं था. So if you are a new director appointed and it's not 6 months yet, since you got appointed in this company. So if you are a new director, then you will not incur any disqualification under 164(2) for a period of 6 months from your appointment. So if you are a new director, then you won't incur any disqualification for a period of 6 months from your appointment in that company. Next is 164(2) is not applicable to government company, which means that government company file ना भी करे तो भी उसके director disqualify नहीं होंगे. Even if the government company makes default, their director won't get disqualified. 164(2) is not applicable to government company. Next is private company may by article provide additional disqualification. Private company has been given exemption that private company can provide some additional disqualification by mentioning in the article of the company. So this was all about section 164 subsection 1 and subsection 2. This subsection you have to remember: 164 1 and 164 2. 164 1 and 164 2. Yes, exactly, Khushi. You are saying correct. Now, next point. There is one procedural requirement that there is one procedural requirement that if this person, this defaulted director, this disqualified director, this person who is disqualified under section 164(2), this person who is disqualified under section 164(2), so if there is any director who is disqualified under section 164(2), before getting appointed or reappointed in any company, he have to file a form DIR 8. If there is any director who is disqualified under section 164(2), before getting appointed in any company, he have to file a form that is DIR 8. And whenever a company makes default under section 164(2), so if any company makes default under section 164 subsection 2, that company has to inform to the ROC that ROC, okay, I defaulted in 164 subsection 2 and my directors got disqualified under section 164(2). So let's say if any company makes a default, it does not file financial statement or annual return for continuous 3 years, or it does not pay the dividend, deposit, interest for a continuous 1 year, then the company has to inform the ROC that ROC, okay, my directors, company has to inform the ROC that ROC, my directors are disqualified under section 164(2), along with giving the name and address of the directors, so that ROC can register that these are the defaulting directors, and the company will inform that in DIR 9 immediately means immediately means turant, forthwith, बट लास्टली विद इन 30 days, 30 दिन से ज्यादा लेट नहीं होना चाहिए. वैसे तो तुरंत इन्फॉर्म करना है, इमीडिएटली. सो दिस कंपनी हैज टू इन्फॉर्म द आरओसी दैट आरओसी माय डायरेक्टर्स गॉट डिस्क्वालिफाइड अंडर सेक्शन 164(2) in the form number DIR 9. When the company has to inform immediately after the default and not later than 30 days from the default. Now when the director disqualification will get removed, now let's say company has paid the pending deposits, director's interest, debenture interest, or let's say company has now filed all the pending AOC 4 and MGT 7. Let's say the company has filed all the pending documents, all the pending financial statement, annual return. Now we have to apply for the ROC, we have to apply for the removal of disqualification to ROC, and then company has to again, when that disqualification will be removed, then again company has to file the ROC. That ROC my director's disqualification is removed. Now they are again qualified. So that application is to be filed in DIR 10. So whenever, let's say they are disqualified for 5 years. So after 5 years, their disqualification will be removed. So now then the company will have to file an application to the ROC that ROC, okay, disqualification is removed, and that application has to be made in DIR 10. So this was all about section 164. I hope this section is crystal clear to all of you. अच्छा, 165 पढ़ने से पहले 167 पढ़ लेते हैं, सिमिलर है. Next is section 167, which talks about vacation of director, and usually students get confused a lot in this. Please understand carefully. बहुत अच्छे से समझाऊंगी, पूरा क्लियर हो जाएगा. वेकेशन ऑफ डायरेक्टर, वेकेशन ऑफ डायरेक्टर, टेंशन मत लेना, बिल्कुल एकदम माइंड को क्लियर रखो, पूरा समझ में आ जाएगा. 2 मिनट में, 5 मिनट में पूरा समझ में आ जाएगा. कीप योर माइंड क्लियर एंड लिसन टू मी केयरफुली. वेकेशन ऑफ डायरेक्टर सेक्शन 167 कोई बहुत बड़ा टॉपिक नहीं है, आराम से हो जाएगा. कब कब डायरेक्टर की सीट वेकेंट हो जाएगी? व्हेन अ डायरेक्टर हैव टू गो, लीव एंड गो द कंपनी. वेकेट मींस ही हैज टू रिमूव हिज पोजीशन एंड जस्ट लीव द कंपनी. टाटा बाय बाय बोल के जाना पड़ेगा. सो उसको अपनी गद्दी छोड़ के जाना पड़ेगा. वेकेशन मींस ही हैज टू लीव द कंपनी, ही हैज टू से टाटा बाय बाय, लीव हिज पोजीशन ऑफ डायरेक्टर एंड से बाय बाय टू द कंपनी. सो व्हेन a director have to leave the company, when a director will when a seat of the director will become vacant, which means that when a director have to give up his position of director and just leave the company and say bye bye to the company and go. That is given in section 167. And what do you mean by vacation? When a director leaves the company, in which all situation the director's seat will become vacant. मतलब हम बोलेंगे नहीं आपको जाना पड़ेगा, किस किस सिचुएशन में डायरेक्टर को छोड़ के जाना पड़ेगा. सो देयर आर सर्टेन सिचुएशन दैट अगर ऐसा हो गया तो डायरेक्टर को जाना पड़ेगा, अगर ऐसा हो गया तो डायरेक्टर को जाना पड़ेगा. सो विल स्टडी वेरियस सिचुएशन व्हेन अ डायरेक्टर सीट विल बिकम वेकेंट. Number 1, if he incur any disqualification. So if he incur any disqualification, let's say he become pagla, he become unsound mind, he become unsound mind. So he is now disqualified under section 164. Yes madam, he is disqualified. So he is disqualified. Along with that we'll say him tata bye bye, okay now you can go. So this is disqualification and vacation go hand in hand. Hand in hand means आप disqualification हुए, ठीक है, अब आपको अपनी गद्दी छोड़ के जानी पड़ेगी, अब आपको विकेट करना पड़ेगा. So they go hand in hand. It's like you are disqualified, okay now you have to say tata bye bye and go. So when a director seat become vacant, when a vacation of director is done, number 1, if there is disqualification under section 164, his seat will become vacant. Whenever a director incur disqualification, he have to just leave the company and go. He have to leave his position of director. So whenever there is disqualification under section 164, and you know what, there is one exception to this, और इसको ध्यान से सुनना वरना उड़ जाएगा, ध्यान सुनना. In case of section 164 subsection 2 अच्छा वो फाइनेंशियल स्टेटमेंट वाला, वो डिपॉजिट वाला, हाँ. So in case of section 164 subsection 2, office shall become vacant in all the company. Office shall become vacant in all the company except the company which is in default. क्या बोला मैडम? In case of section 164 subsection 2, office of director will become vacant in all the company except the company which is in default. Q, this is linked with section 164. How? Giving a quick example that this is the person, this is Mr. A, and this Mr. A is in director of 2 companies. He is the director of, let's say, ABC Limited also, and he is the director of XYZ Limited also. So Mr. A is the director of 2 companies, number 1 company and number 2 company, and let's say this ABC Limited defaulted in filing AOC 4 for 3 years, which means that this ABC become defaulting company. This company defaulted in filing AOC 4 for 3 years. So now all the directors of this ABC Limited will get disqualified. Disqualified for what? Disqualified to get reappointed in the same company. reappointed in the same company and appointed in any other company. मतलब अब वो किसी नई कंपनी में अपॉइंट नहीं हो सकते और इस कंपनी में रीअपॉइंट नहीं हो सकते, विच मीन्स दैट दे कैन कंटिन्यू ना इस कंपनी में प्रेजेंट टर्म के लिए, तो दे कैन कंटिन्यू, दे कैनॉट गेट रीअपॉइंट इन एबीसी लिमिटेड, बट दे कैन कंटिन्यू इन एबीसी लिमिटेड फॉर द प्रेजेंट टर्म, and when this present term will end, after that they cannot be reappointed in ABC Limited. Are you getting this point? Which means that ABC Limited में वो लोग रीअपॉइंट होने के लिए डिस्क्वालीफाई होंगे, तुरंत उनको छोड़ के नहीं जाना पड़ेगा, तुरंत सीट वेकेट नहीं करना पड़ेगा, विच मीन्स दैट दिस मिस्टर ए डोंट हैव टू वेकेट द सीट इन एबीसी लिमिटेड immediately. Why? Because he is disqualified to get reappointed. He can continue for the present term. Now you will ask, ma'am, what about XYZ Limited? Ma'am, what about XYZ Limited? तो XYZ Limited तो के बारे में तो कुछ नहीं लिखा है, यहाँ पर लिखा है कि मिस्टर ए अगर एक से ज्यादा कंपनी में डायरेक्टर हैं तो ये कंपनी जो डिफॉल्ट कर रही है उसमें वो वेकेंट नहीं होंगे, मतलब उसमें वो कंटिन्यू कर सकते हैं, लेकिन बाकी सारी कंपनी जिसमें वो डायरेक्टर हैं उसमें उनको इमीडिएटली वेकेट करना पड़ेगा, which means that let's say Mr. A is director in two company, ABC also, XYZ also, and ABC defaulted in filing AOC4 for 3 years, which means that Mr. A will get disqualified to get reappointed in ABC Limited. But Mr. A can continue for the present term in ABC Limited. Mr. A need not vacant his seat in ABC Limited. Mr. A need not vacant his seat in ABC Limited. However, he need to vacant his seat in XYZ Limited. उनको XYZ Limited में अपनी सीट छोड़ के जाना पड़ेगा. He have to vacate his seat in the XYZ Limited immediately. But in ABC Limited, he can continue to be the director for the present term, and when the present term will end, after that, he cannot be reappointed in ABC Limited. I hope this point is clear to you, all of you, that in case of 164 subsection 2, the office of director shall become vacant in all company in which he is director. Except the company which is in default. Which means that the company which is in default, the director will not vacate his seat in the company which is in default. But for all other company, he have to immediately vacate his seat. I hope this point is crystal clear to all of you. Next is, we are studying the situation when a director seat will become vacant. ऐसी कौन सी situation है जब director की seat खाली हो जाएगी, when he has to leave the company. So number 1 is disqualification under section 164. The two other points are, you know what, these points were the point in 164 only. तो आप बोलोगे मैम इसको अलग से लिखने की क्या जरूरत थी? I'll tell you the difference. Basically, if a person is, thank God, if a person is disqualified by court or tribunal order, then also he have to vacate his seat. And if a person is convicted for an offense for 6 months or more, then also he will be his seat will become vacant. His seat will become vacant. You will say, ma'am, this point were there in 164 also, na? I know this point were there in 164. However, these 2 points are mentioned separately. Why? You know what? Because there is a provision given that although if the court has said, okay, you are disqualified, or you have been convicted, let's say for 6 months or more, then although you will be disqualified immediately, आप तुरंत disqualified हो जाओगे, you will be disqualified immediately, but आपको छोड़ के नहीं जाना पड़ेगा तुरंत, but you don't need to vacate your position immediately, you don't need to vacate for 30 days, you don't need to vacate your seat for 30 days. मतलब आप disqualified हो जाओगे लेकिन 30 दिन का समय मिलेगा आपको छोड़ के जाने के लिए, पैकिंग वैकिंग करने के लिए, हाँ, नॉट पैकिंग करने के लिए, अपील करने के लिए, ठीक है. So here one point is given that if you are disqualified by court or tribunal order, or you are convicted for offense for 6 months or more, although you will get immediately disqualified, but you don't need to vacate immediately, you don't need to vacate for 30 days. 30 days क्यों 30 दिन का टाइम मिला? So that you can file an appeal, and if you file the appeal, देन जब तक अपील चलेगी, जब तक सुनवाई चलेगी, तब तक तो आपको वैसे भी वेकेट नहीं करना है, राइट? सो यू डोंट नीड टू फाइल एन अपील. sorry, you don't need to vacate for 30 days. However, if the appeal is filed within 30 days, then you don't need to vacate your seat till the expiry of 7 days after the order is disposed. इसका क्या मतलब है, मान के चलो ये डेट है जिस दिन हम डिस्क्वालीफाई हो गए, ये डेट है जिस दिन where we get the conviction order, this is the date where we got disqualified. So you will get 30 days, you will get 30 days to vacate your seat. You cannot, it means that you need not vacate your seat within 30 days. Okay, immediately you do not need to vacate your seat. 30 दिन तक आपको vacate करने की जरूरत नहीं है. उसके बाद एक छोटा सा पॉइंट लिखा है कि लेट्स से आई प्रेफर्ड अपील. 30 दिन खत्म ही होने वाले थे कि मैंने यहाँ अपील कर दिया, तो अब अपील जब तक चलेगी तब तक भी छोड़ने की जरूरत नहीं है, हम अपील का वेट करेंगे. अब लेट्स से अपील इस दिन डिस्पोज ऑफ हो गई और रिजल्ट जो है वो मेरे अगेंस्ट आ गया, तो अब इसके डिस्पोज ऑफ होने के नेक्स्ट 7 डेज तक भी मुझे क्या करना पड़ेगा, नेक्स्ट 7 डेज, इसके डिस्पोज ऑफ होने के नेक्स्ट 7 डेज तक भी मुझे वेकेशन करने की जरूरत नहीं है. क्यों 7 दिन का एक्स्ट्रा टाइम मिला, ताकि मैं 7 दिन के अंदर सेकेंड अपील फाइल कर सकती हूँ. तो अगर मैंने 7 दिन के अंदर सेकेंड अपील फाइल कर दिया, उसके बाद मैं थर्ड अपील फाइल नहीं कर सकती हूँ. सो फाइनली वो सेकेंड अपील जब तक डिस्पोज ऑफ नहीं हो जाता तब तक मुझे वेकेंट करने की जरूरत नहीं है. विच मीन्स दैट देयर इज अ पॉइंट गिवन दैट यू नीड नॉट वेकेंट योर सीट for 30 days after the disqualification. However, if you have preferred an appeal, so when that appeal will get disposed of after the 7 days, within 7 days, you don't need to vacate. And if within 7 days second appeal is preferred, then you have to do vacation only after the disposal of the second appeal. You need not vacate your seat until the disposal of second appeal. So are you getting this point that आपको vacation करने की जरूरत नहीं है 30 दिन तक. और अगर 30 दिन में अपील हो गया तो अपील जिस दिन डिस्पोज ऑफ होगा उसके 7 दिन तक आपको वेकेट करने की जरूरत नहीं है. और अगर इन 7 दिन के टाइम में सेकेंड अपील फाइल हो गई तो जब तक वो सेकेंड अपील डिस्पोज ऑफ नहीं हो जाती आपको वेकेट करने की जरूरत नहीं है. सो ये वन पॉइंट इज गिवन, यू डोंट नीड टू वेकेट योर सीट for 30 days from the date of disqualification. However, if you filed an appeal within that 30 days, then we will wait till the order of that appeal, and you don't need to vacate until the expiry of 7 days from the date of disposal, from the date of order. However, if you have preferred second appeal within 7 days, then you don't need to do the vacation till the further appeal is disposed of, till the second appeal is disposed of. I hope this point is crystal clear to all of you. Next, we are done with 3 points. These 3 points were related to disqualification. Now we will study some more points that when a seat of the director will become vacant. Number 1, if there is a section 184 which talks about disclosure of interest of directors. So if there is one point that the directors have to disclose their interest in the board meetings, and also if there is any contract in which they are interested, they have personal interest, that interest also they have to disclose. So there is one point that either you enter in a contract in contravention with 184. कॉन्ट्रावेंशन मतलब आप इंटरेस्टेड होना तो आपको वोट करना अलाउड नहीं होता है, लेकिन आप इंटरेस्टेड थे उस कॉन्ट्रैक्ट में, फिर भी आपने वोट कर लिया, तो आप जो है वो डिस्क्वालीफाई, वो वेकेंट हो जाना पड़ेगा. आपको अपनी सीट तुरंत वेकेट करके जानी पड़ेगी, कंपनी को टाटा बाय बाय बोल के छोड़ के जाना पड़ेगा. सो ये वन पॉइंट इज गिवन. व्हाट इज द पॉइंट मैम? दैट द पॉइंट इज if you enter into contract arrangement in contravention with 184, or you did not enter into contract arrangement but you did not disclose your interest. If you fail to disclose your interest in contract or arrangement in contravention with 184, then also your seat will become vacant and you have to say tata bye bye and go. अगर 184 के अंदर या तो आपने अपना इंटरेस्ट डिस्क्लोज नहीं किया, या तो इंटरेस्ट डिस्क्लोज किया था बट आप वोट कर दिए, आप कॉन्ट्रैक्ट में एंटर कर दिए इसके 184 के कॉन्ट्रावेंशन में, तो आपकी सीट वेकेंट हो जाएगी. विच मीन्स दैट ईदर यू फेल्स टू डिस्क्लोज योर इंटरेस्ट और यू entered into contract when you are interested. So you entered into contract in contravention to 184. So in all both the cases your seat will become vacant and you have to say tata bye bye and go. Next is when you are removed. Remove means धक्के मार के निकाल दिया. So there is one section you will study just now, 169. 169 talks about removal, which says that if you are removing a director, आपको नहीं चाहिए, डायरेक्टर अच्छा नहीं है, तो आप अगर निकाल देते हो उसको धक्के मार के, तो उसको टाटा बाय बोल के जाना पड़ेगा. सो इफ अ डायरेक्टर इज रिमूव्ड basically there is a section for removal 169. So if a director is removed, then he has to vacate his seat. Next, he absent himself from all the board meeting for 12 months. For the continuous 12 month एक भी board meeting में नहीं आया वो, तो क्या करेंगे उसको director रख के, सर बाय, अब आने की जरूरत भी नहीं है, जाइए permanent. So if there is a director who absent himself from all the board meeting for continuous 12 months, then his seat will become vacant. Doesn't matter he have taken leave of absence or not, doesn't matter उसने leave लिया था कि नहीं. If he absent himself from all the board meeting for 12 months, his seat will become vacant. Doesn't matter he has taken leave of absence or not. Next is, if he is appointed as the director by virtue of his employment in holding subsidy associate, क्योंकि वो हमारी होल्डिंग का एम्प्लॉय था इसीलिए हमने उसको डायरेक्टर अपॉइंट किया था, क्योंकि वो हमारी सब्सी का एम्प्लॉय था इसलिए हमने उसको डायरेक्टर अपॉइंट किया था, एंड अब वो होल्डिंग या सब्सी का एम्प्लॉय नहीं रहा, and he ceases to hold that position, that employment, then he will also cease to be a director of the company and he has to vacate his position. So if that person is appointed as the director by virtue of his employment in holding subsidy associate, because he was employed in holding, that's why we employed him as the director. And now if he ceases to hold that position of employee in holding subsidy associate, we will also remove him from the directorship of the company and he has to vacate his seat. He has to say tata bye bye and go. So these are the 8 points where a seat of director will become vacant or a position of director will become vacant. So how will you remember this? Now first 3 points are related to 164. First 3 points are related to 164. 164, we studied disqualification just now, right? And these 2 points are also from disqualification only, right? So first 3 points are related to 164. Now just add 20. 164, 184, 164, 184. So you'll be able to remember. हाँ 3 point 164 वाले थे, 2 point 184 वाले हैं. So this is the memory technique to easily remember all the points. ऐसे याद करोगे हो जाएगा. 3 points अच्छा, 3 point were related to हाँ 164. 2 point were related to 184. Just add 20. हाँ 164, 184. It is sounding similar. Just add 20. 164, 184. Okay. 2 point were related to 184. We are done with 5 points. Easily एकदम चुटकियों में remember हो जाएगा. After that there are 4 extra point. एक तो मान के चलो नंबर 1 मेंबर्स नहीं चाहते, मेंबर्स ने निकाल दिया, मेंबर्स रिमूव्ड हिम. दूसरा वो खुद नहीं चाहता, उसने बोर्ड मीटिंग में आया नहीं. सो 1 मेंबर्स डोंट वांट, मेंबर्स हैव रिमूव्ड हिम. नेक्स्ट इज ही हिमसेल्फ डोंट वांट, ही हिमसेल्फ डोंट वांट्स, ही डिडंट अटेंडेड द मीटिंग. 2 पॉइंट हो गया. और लास्टली एक एम्प्लॉयमेंट वाला, एक एक्स्ट्रा पॉइंट. सो हाउ यू विल रिमेंबर दिस? यू विल रिमेंबर दिस 3 plus 2 plus 2 plus 1. 3 plus 2 plus 2 plus 1. This is how you will remember it. 3 164 related, 2 184 related. 2 points were director himself don't want and members don't want. And here एक एम्प्लॉयमेंट वाला पॉइंट था, लास्ट एक एम्प्लॉयमेंट वाला पॉइंट था. बस ऐसे ऊपर ऊपर से याद रखो, पूरा याद आ जाएगा. ठीक है. 3 points were related to 164, 2 points were related to 184. 2 directors are, एक डायरेक्टर खुद नहीं चाहता, एक मेंबर्स नहीं चाहते, and 1 point was related to employment. This is how you can easily remember all the 8 points of vacation of director. That if he disqualified under 164, हाँ, और 2 point 164 के ही थे कोर्ट ऑर्डर वाले, that if he is disqualified by court order or if he is convicted for offense for 6 months or more. Next is 184. हाँ, he entered into contract in contravention to 184. He did not disclose his interests and in contravention to 184. Now he himself don't want. Okay, he has not attended the board meeting for continuous 12 months. मतलब वो खुद ही नहीं चाहता ना, तभी तो board meeting नहीं आ रहा है. He himself don't want. He did not attended the board meeting for 12 months. He will be removed. Next is members don't want. Members have removed him. Last point employment वाला था कि he is appointed by virtue of his employment. He is appointed by virtue of his employment in holding subsidy associate and he ceased to hold that position. So are you getting this point? कभी confuse नहीं होगे. मैं अपने executive time पे बहुत confuse होती थी और मैं वेकेशन के 1-2 पॉइंट को उसमें डिस्क्वालिफिकेशन में डाल देती थी, डिस्क्वालिफिकेशन के 1-2 पॉइंट को वेकेशन में डाल देती थी. सो ऐसे लिंक करके याद करो. यू वोंट कंफ्यूज बिटवीन 9 पॉइंट्स ऑफ डिस्क्वालिफिकेशन एंड 8 पॉइंट्स ऑफ वेकेशन. डिस्क्वालिफिकेशन में क्या था? डिस्क्वालिफिकेशन में था 3 plus 3 plus 3. 3 पॉइंट एक जैसे थे, अनसाउंड माइंड, इंसॉल्वेंट और अप्लाइड फॉर इंसॉल्वेंट. फिर 3 पॉइंट कोर्ट वाला था कि कन्विक्टेड फॉर 6 months और मोर एंड कोर्ट डिस्क्वालिफाइड बाय कोर्ट ऑर्डर एंड convicted under 188. So these 3 points were similar. Lastly 3 points were extra. like you did not have DIN 185, so 165, sorry, you do not have DIN, you accepted directorship beyond 165, 165 की जो लिमिट थी उससे ज्यादा डायरेक्टरशिप आपने एक्सेप्ट कर ली. ओके 165. एंड लास्टली वन मोर पॉइंट, कॉल मनी पे नहीं किया, पैसा पे नहीं किया, कॉल मनी. Lastly, one more point, call money. You did not pay call money. So this is how you will remember all the 9 points of disqualification and all the 8 points of vacation. Is it easy to remember? Is it easy to understand and remember properly all the points of vacation and disqualification? And are you getting the difference between vacation and disqualification? Disqualification, okay, now you are disqualified. Vacation means, okay, you have to leave and go. Tata bye bye and go. You have to leave your seat. You have to leave your position. Okay. So this is all about section 167. There is one small point in 167 that if all the director become vacant, if the position of all the director become vacant, now who will manage the company? Who will appoint the director? So the law says that in case all the director become vacant, then the promoters will appoint the required director. However, if there are no promoters, then central government will appoint the director until the shareholders are appointed in general meeting. Next is section 168, resignation of director. Resignation. I don't want to work in this firm. Can I resign? I can resign. I don't want to work in this company. It's my wish. Can I resign? Yes. Simply, I have to give a notice in writing that why you are resigning. It's like a breakup with the company. So, can I do breakup? Yes. But I have to give reason that why I am doing breakup with the company. So, I have to give notice in writing. In that notice, I have to give a reason. It's over, it's not working. I have to give the reason to the company that it's over. I don't want to be your director anymore. Okay, so let's say this is the retiring director and this is the director who want to resign. So what he have to do, he have to give a notice in writing to the company and board will take a note of that. Now there's one point I already told you that whenever a director is appointed or reappointed, I already told you that whenever a director is appointed or removed or resign or anything, there is a change in director, you have to file a form to the ROC, that is DIR 12, within 30 days and inform the ROC about such appointment or cessation. So your director is going, you have to inform to the ROC. Gum baad mein manana, pehle ROC ko inform karo. ROC, this director is resigning and the company has to file a form DIR 12 within 30 days to ROC. Along with that, website mein bhi post karna hai, board support mein bhi disclose karna hai. Uske baad, there is one more requirement that this retiring director also have to inform the ROC that ROC, I am resigning. Company ने मुझे नहीं निकाला, तुमने मुझे नहीं छोड़ा, मैंने तुमको छोड़ा है, मैंने रिजाइन किया है. सो रिटायरिंग डायरेक्टर will also inform to the ROC that ROC, I resign from this company. And he will give a reason that why he resigned from that company. So this retiring director also have to file a form DIR 11 to the ROC informing about his resignation and giving a reason for his resignation. And this DIR 11 has to be filed within 30 days. And you know what? This filing DIR 11 is optional. Filing DIR 11 is optional. Matlab it's the wish of director. He can file DIR 11 or he may not file DIR 11. It's not a non-compliance. It's an option given that you can file DIR 11 or if you don't want, it's okay if you don't file the DIR 11. So here if the resigning director wants to inform, then he can also file the DIR 11 if he want to disclose the reason. Like मान के चलो ये कंपनी कुछ फ्रॉड कर रही थी, इसको बताना है कि मैं क्यों छोड़ा कंपनी, क्योंकि कंपनी फ्रॉड कर रही थी, कंपनी चीट कर रही थी, तो इसलिए मैंने छोड़ा, तो उसको आरओसी को बताना है तो फाइल कर सकता है. सो इट्स लाइक ऑप्शनल, इट्स एज पर द विश ऑफ रिटायरिंग डायरेक्टर. नाउ देयर इज वन पॉइंट दैट इफ दिस पर्सन इज अ फॉरेन डायरेक्टर, how will he sign DIR 11? How will he file DIR 11? So he may authorize any CA in practice, CS in practice, CMA in practice or any resident director to sign and file DIR 11 on his behalf. So this is the small section 168 subsection 1. Now, there is a subsection 168 subsection 2 which says that from when this resignation will be effective. This resignation will be effective from the date mentioned in the notice or the date of the receipt of notice by the company, whichever is later. Which means that जो date notice में लिखा हुआ है, let's say this is the notice and in this notice the date mentioned is 12th May. However, the company received this notice on 13th May. Then, from when the resignation will be effective? Resignation will be effective from 12th or 13th, whichever is later. Which means that resignation will be effective from 13th May. Date mentioned in notice or the date of receipt of notice by the company, whichever is later. Next, what happens if all the director resign? If all the director resign or all the directors resign, then who will appoint? Promoter will appoint. And if there is no promoter, then central government will appoint the डायरेक्टर टिल द डायरेक्टर आर अपॉइंटेड इन जनरल मीटिंग. अरे सारे डायरेक्टर रिजाइन कर दिए तो कंपनी कौन चलाएगा? कोई तो लगेगा ना. तो टेम्पररी डायरेक्टर कौन अपॉइंट करेगा? प्रमोटर करेगा. प्रमोटर नहीं है तो सेंट्रल गवर्नमेंट करेगा. सो इफ ऑल द डायरेक्टर रिजाइन टेम्पररी वी हैव टू अपॉइंट अ डायरेक्टर. इफ देयर इज प्रमोटर, प्रमोटर विल अपॉइंट. इफ देयर इज नो प्रमोटर, सेंट्रल गवर्नमेंट विल अपॉइंट एंड देयर दे विल बी अपॉइंटेड टिल the normal ordinary director is appointed in the general meeting. So this is all about section 168. This is all about section 168. There is the next section, section 169. Section 169 talks about removal of director. So there is the next section, section 169. Okay. What do you mean by removal of director? Removal of director means धक्के मार के निकालना. You don't like this person. मुझे तेरा चेहरा पसंद नहीं है. आथू. So if you want to remove any director, he is not working properly. Can you do so? Yes. Who has the authority to remove director? Obviously shareholders. बोर्ड मत बोलना, एक खींच के मारूंगी. मार सकती हूँ मैं वर्चुअल चाटा. ठीक है. So who has the authority to remove a director? Obviously shareholders. Now why? Because owner will decide now who will manage their company. So owners have the authority to appoint a director by passing ordinary resolution. So who will have authority to remove a director? Obviously shareholders now by passing ordinary resolution. Do you remember 152? Do you remember 152? Don't say no. I want to listen. Yes. I like yes. Do you remember this section 152? Here I taught you that who appoints director. So I told you that every director is appointed by general meeting. Every director is appointed in general meeting by shareholder by passing ordinary resolution. So you have to pass ordinary resolution to appoint a director. Yes. So who can remove a director? Obviously shareholders now. Obviously shareholders are the authority. They have the power to remove a director. So there's one point that who can remove a director. Remove means you want to remove a director before his tenure, before the expiry of his tenure. Then a company can remove director by passing ordinary resolution. बहुत बड़ा बड़ा लिखा है OR OR OR. You have to pass OR for removing any director before the expiry of his tenure. But हाँ, हर किसी को आखिरी मौका मिलता है. Even before hanging somebody, we ask him what is your last wish. So before declaring anybody दोषी, the court says that you want to say anything, आपको सफाई देनी है अपने अपने बचाव में कुछ. So court will give what? Opportunity of being heard. Similarly, company before removing any director, we will give him opportunity of being heard. You want to say anything? Okay. तुम भी कह लो अपने मन की. So before removing him, we will give him opportunity of being heard. Opportunity of being heard. 3 type of director can never be removed. Number 1, if director is appointed under 163. 163 we will do just now. If that director is appointed under section 163, then he cannot be removed. If director is appointed by tribunal under section 242, there is a chapter you must have studied, operation and mismanagement. There is a topic you must have studied in part A, operation and mismanagement, which says that if the company is doing wrong, company is doing fraud, company is doing any fraud with the creditors or the members, then the company is doing something wrong, operation and mismanagement, then the court has the power to appoint the director for the company. तो उस केस में ना एनसीएलटी अपने एक बंदे को कंपनी में डायरेक्टर बना देता है. उस डायरेक्टर को आप टच भी नहीं कर सकते, उस डायरेक्टर को ऐसे चिमटी भी नहीं काट सकते, उस डायरेक्टर को कुछ नहीं कर सकते, आप रिमूव नहीं कर सकते. सो व्हेन द कोर्ट NCLT appointed his person as the director of the company, bro, you cannot remove that director. वो NCLT भगवान का डायरेक्टर है, ठीक है, NCLT अपॉइंट किया. You cannot remove a director who is appointed by tribunal under section 242, appointed by tribunal. Next is nominee director. Nominee director is either appointed by any banks, FIs or government. So nominee director वो एक specific term, fixed term के लिए अपॉइंट होता है जो किसी का नॉमिनी होता है. जैसे अपन ने लोन लिया, if let's say we have taken loan from SBI, 5,000 crore loan. So SBI have given this much loan. SBI will appoint his nominee director in our board. So that nominee director has a fixed tenure that cannot be removed. So you cannot remove director under 163. What is 163? We will study now. You cannot remove director under 163. You cannot remove director under director appointed by tribunal, director appointed by NCLT under section 242. You cannot remove a nominee director. These three type of director can never ever be removed. आपको पता है घुमा फिरा के केस लो आएगा एग्जाम में. Question will be asked, sir, there was a director, Mr. X, of a company XYZ Limited, and the board of the company want to remove this person. और लास्ट में लिखा होगा ना, this director was ना nominated by government. बताओ क्या होगा? Your answer should be no, bro, we cannot remove this. Why? Because he is nominee director. So you should remember that you cannot remove these three kind of director. इनको टच भी नहीं कर सकते, ये हमारे जमाई हैं, ठीक है, ये हमारे जमाई हैं, तो इनको आप अच्छे से खिला पिला के रखोगे. So following director cannot be removed. This three type of director cannot be removed. This three type of director cannot be removed. However, there is one exception, that if ID is reappointed by SR. अरे मैडम क्या बोला, रुको मैं आपको याद दिलाती हूँ, थोड़ा फ्लैशबैक में चल जाते हैं, टाइम ट्रैवल कर लेते हैं. Let's time travel, and I want to remind you section 149. Remember this we studied yesterday only na. हाँ, yesterday we studied this term of ID, that independent director will be appointed for fixed term. First term will be of maximum 5 years. We will appoint him by passing OR, and he is eligible for reappointment, and he can be reappointed for second term by passing special resolution, SR. Do you remember this? Yes madam, we remember this. And do you know that if independent director is reappointed for second term by passing SR, तो SR पास करके अपॉइंट किया है ना, तो अब रिमूव करने के लिए भी SR लगेगा. आर यू अंडरस्टैंडिंग दिस पॉइंट, दैट टू रीअपॉइंट ID you have to pass SR. Now if you want to remove this ID, then you again for removal you have to pass SR. Why? Because you have reappointed that ID for the second term by passing SR. Are you getting this point? Biru. So there is one point, that if ID is reappointed by passing SR, if ID is reappointed for second term by passing SR for second term, if ID is reappointed for second term by passing SR, then for removal also you have to pass special resolution. So this is the small point about removal of director, that you have to pass ordinary resolution given in section 169 subsection 1. Now section 169 subsection 2 says that if you want to remove the director or you want to appoint somebody else in place of the removed director, let's say our company have a director Salman Khan. We want to remove Salman Khan. सलमान खान नहीं पसंद है, इसको निकालना है. हमारे कंपनी में कैटरीना कैफ भी डायरेक्टर है, तो सलमान खान को निकालना है और उसके बदले हमें विकी कौशल को अपॉइंट करना है. सो लेट्स से वी वांट टू रिमूव सलमान खान. भाग यार तू भाग. So we want to remove Salman Khan and we want to appoint Vicky Kaushal in place of Salman Khan. Then for this number 1 and number 2 activity, you have to file special notice under section 115 Do you remember section 115? I taught you day before yesterday in general meeting chapter that for 5 purpose you need to file special notice, and I told you that the 2 purpose will come in 169. This is 2 purpose. Number 1 is for removal of director, also you have to file a separate special notice under 115, and for appointment of any other director in place of the removed director, for this also you have to file a separate special notice as per section 115. Are you getting this point? इसके लिए separate special notice लगेगा, इसके लिए separate special notice. So for these two matter, number 1 for removing a director, you also have to file a separate special notice, and for appointing a director other than removed director, then also for this also you have to file a separate special notice as per section 115. Do you remember the process of section 115, that members have to give special notice to the company before the meeting? Do you remember? Let me remind you section 115. Let's time travel. 2 minutes flashback. Section 115. Do you remember this? We studied in general meeting chapter that there are certain resolution which require special notice. Procedure बहुत simple था. Procedure was very simple, that members have to give special notice to company, and then company will forward that special notice to all the member either individually or through newspaper. छोटी सी बात थी. So member have to give special notice to company will forward that special notice to all the members. And here also I taught you that there are 5 matters which require special notice. 2 matters are given in 169, 2 matters are given in 140, and 1 any other matter as the article specified. These 2 matters we are studying now. To remove a director before his tenure, to appoint another director in place of removed director. याद आया क्या? Oh my god. ये जिंदा है. बट इसका कुछ घूम गया. जस्ट अ मिनट. नहीं जाना नहीं. ये देखो, इसकी नींव जो है ना, ये गिर के घूम गई थी, मिल गई बट ठीक है. It's fine. Great. So now do you remember this section 115? Yes, madam, we remember. So now coming back to section 169. Here it is given that if you want to remove a director or you want to appoint any other person in place of removed director, for that special notice is required. Next, madam, what is the procedure of special notice? It's very simple, that members will give special notice to company will inform all the members, and also along with that there is one additional procedure given here in 169. What is the additional procedure given in 169? 169 says that company has to inform that respective concerned director. Company will inform, अरे तुम्हें निकालने का बुलावा आया है, तुम्हें निकालने का संदेशा आया है. So company will inform this director that members want to remove you. So company will inform this concerned director, and if that concerned director want, he can give his written representation. मतलब वो अपनी सफाई में कुछ बोल सकता है, मेरे को क्यों निकाल रहे हो, ऐसा वैसा, मतलब इमोशनल, you know, Not exactly emotional. Basically, he can give clarification that he has not done any default or anything like that, that why he is being removed. So if this director want, then he can make a written representation, and then it's the duty of company to forward this written representation to all the member. So either if sufficient time is left, then हम इस representation की copy सारे members को दे देंगे. If sufficient time is left, we will send a copy of this representation to all the member. However, if sufficient time is not left, then we will say sufficient time is not left, we are not able to send the copy of this representation to all the members, but we will definitely read out this in the meeting. In the meeting, we will read out your representation loud. But you know what, there's one point given, that if this representation is for defamatory or unnecessary publicity, then we can make application to central government, and if central government says that no, you are using your power for unnecessary publication, unnecessary publicity or defamation, then NCLT might say that is representation को फाड़ के फेंक दो. You don't need to send this representation to members, and you don't need to even read out this in the meeting. So this is the small point. Now let's say we remove a director, but we did not appoint any other director in place of the removed director. So there will be vacancy. Yes. How that vacancy will be filled? Number one, either that vacancy will be filled in the same meeting by appointing any other person in place of the removed director, but for that also you have to file a special notice. However, if this vacancy is not filled, then this will be deemed as casual vacancy, and this vacancy will be filled by board as per section 161 subsection 4. Remember, we studied yesterday section 161. Yes. So if there is any vacancy, so either that vacancy will be filled in the same meeting by appointing any other person as a director in place of the removed director, but obviously for that you need to file special notice. You have to file a separate special notice for the appointment of any other person. Then in the same meeting vacancy will be filled. However, if in the same meeting the vacancy is not filled, then that will be deemed to be casual vacancy under section 161 subsection 4, and the board will fill up that casual vacancy. What will be the tenure of that new director? That tenure of new director will be the remaining tenure of the removed director. He is not eligible for reappointment. Con removed director. जिस डायरेक्टर को निकाल दिए ना, उसको रीअपॉइंट नहीं कर सकते उस कंपनी में. सो दैट रिमूव डायरेक्टर मतलब ही क्या रह जाएगा, इसको तो हमने निकाला है, आप रीअपॉइंट करने की बात कर रहे हो. So it's like removed director cannot be reappointed. Removed director is not eligible for reappointment. Removed director has right to receive compensation. If there is a terms and conditions in the contract and you are removing him before expiry of his tenure, then he has right to claim compensation. आप ऐसा नहीं बोल सकते हम उसको compensation नहीं देंगे. No. Removed director have right to receive compensation for loss of office as per the terms of contract. So this is all about section 169, and we are done with section 169. So आपको मैं थोड़ा सा सेक्शन याद करा देती हूँ. तो अभी हमने पढ़ा 160, 161. 160 was appointment of person other than retiring director. वो जो 1 लाख रुपए डिपॉजिट वाला सेक्शन था ना, वो 160 अपॉइंटमेंट ऑफ पर्सन अदर देन रिटायरिंग डायरेक्टर. 161 के 4 भाग थे, सबसेक्शन 1, सबसेक्शन 2, सबसेक्शन 3, सबसेक्शन 4. सबसेक्शन 1 was for all additional director, subsection 2 was for alternate director, subsection 3 was for nominee director, subsection 4 was for casual vacancy. 162 अपॉइंटमेंट ऑफ डायरेक्टर टू बी वोटेड इंडिविजुअली. वो पलक और खुशी वाले एग्जांपल की अलग अलग वोट करना पड़ेगा. अपॉइंटमेंट ऑफ डायरेक्टर टू बी वोटेड इंडिविजुअली. 163 अभी करना है. उसके बाद 164 डिस्क्वालिफिकेशन, 167 वेकेशन, 167 वेकेशन, 168 रेजिग्नेशन, 169 रिमूवल. सो नाउ वी आर लेफ्ट विद टू सेक्शन, 163 and 165 and 166. 3 sections are left, 165, 166 and 163. Now, if you'll come to section 165. दिस इज अगेन इंपॉर्टेंट सेक्शन. वैसे डायरेक्टर में सभी इंपॉर्टेंट है, कुछ भी नहीं छोड़ सकते आप. पार्ट बी में तो यू कांट स्किप एनीथिंग, यू हैव टू रीड एवरीथिंग. सो नाउ पार्ट बी, सेक्शन 165 says that what is the maximum number of directorship, which means that a one person can become director in maximum how many company. So the overall limit of directorship is 20, that you can become director in maximum 20 company. Next is you know what, you can become a director in maximum 20 companies. However, if I talk about public company, then you can become director in maximum 10 public companies. So there is a specific limit given that overall 20 company but public 10 company. So you cannot be appointed as a director in more than 10 public companies. You can become a director of maximum 10, you can become a director of maximum 10 public companies. And you know what, here those private company which are holding or subsidy of public company will be considered here. So those private company which are holding or subsidy of public company, for this purpose they will be deemed to be a public company, and even those company will come under this limit, 10 limit. This is given in section 165. So if I ask you, I am director in 10 private company, 10 public company. Is it okay? Yes. 12 private company, 8 public company. Yes. Why? Because overall it is within the limit of 20 and the public company is within the limit of 10. Now my question is, I am director in 12 public company, 8 private company. Is it okay? No. Why? Because although overall I am within the limit of 20, but still I cannot become director of more than 10 public companies. So that is why this is not okay. I am director of 20 private companies. Is it okay? Yes. Private company, there is no limit. I can become director of 20 private company. But if I am director of 20 public company, it is not okay. Because I can become director of maximum 10 public companies. I hope this point is crystal clear to all of you. So here one point is given. I am director in 8 private company, out of which 2 private company are subsidiary of public company and 1 is holding of public company. So this 3 private companies will be considered as public company only. And also I am director in 8 public companies. Is it okay? No, it's not okay. Why? Because these 3 companies will be deemed to be public company and this 8 public company. So 8 plus 3, 8, 9, 10, 11. You are director in 11 public company, which is not allowed. So are you getting this point, that you can be director in maximum 20 companies? However, in public companies you can become director in maximum 10 public companies, and in counting this, if there is any private company which is holding or subsidy of public company, then that will be included in this limit of 10. Now there is some additional requirement given in regulation 17A of SEBI LODR regulation. So there is some additional point given in the SEBI LODR regulation which says that यू कैन बिकम डायरेक्टर इन मैक्सिमम 7 लिस्टेड कंपनी. क्यों? क्योंकि लिस्टेड कंपनी के ज्यादा कंप्लायंसेस होते हैं ना, लिस्टेड कंपनी में लोड ज्यादा होता है. सो देयर इज मोर लोड इन लिस्टेड कंपनी, सो दैट्स व्हाई नंबर इज लेस फॉर लिस्टेड कंपनी. लाइक सोचो प्राइवेट कंपनी में कोई लोड नहीं होता है, इसलिए आप 20 प्राइवेट कंपनी के बन सकते हैं. Public company there is load, so limit is now less, 10. In listed company there is more load, so limit is more less. So you can become director in maximum 7 listed company. Now if there is another requirement only for independent director, that you can become independent director in how many company. So if I want to become independent director in 7 listed company, can I become? The answer is yes, if I am not the MD or WTD in any company. So if I am not managing or whole time director in any company, मतलब मैं कहीं भी फुल टाइम नहीं दे रही हूँ, तो उस केस में मैं 7 लिस्टेड कंपनी में इंडिपेंडेंट डायरेक्टर बन सकती हूँ. सो आई एम सेइंग दैट इन हाउ मेनी कंपनी आई कैन बी अपॉइंटेड एज इंडिपेंडेंट डायरेक्टर इफ आई एम नॉट द MD or WTD, मैनेजिंग डायरेक्टर और होल टाइम डायरेक्टर इन एनी अदर कंपनी. I am not MD WTD in any company, then I can become independent director of maximum 7 listed company. However, if I am MD or WTD of any other company, मैं कहीं भी MD WTD हूँ, in that case I can become independent director of maximum 3 listed company. If I am MD or WTD anywhere in any other company, then I can become independent director of maximum 3 listed company. Are you getting this picture? Are you getting this point? Some additional point that this includes alternate directorship. मैं 10 कंपनी में नॉर्मल डायरेक्टर हूँ, 20-15 कंपनी में ऑल्टरनेट डायरेक्टर हूँ, चलेगा क्या? नहीं चलेगा. क्यों? क्योंकि ऑल्टरनेट डायरेक्टर को भी इंक्लूड करते हैं और 10 + 15 25 हो जाएगा. सो इफ आई एम नॉर्मल डायरेक्टर इन 10 कंपनी, alternate director in 15 company, it's not okay. Why? Because even this alternate directorship is included in the limit of 165. I also taught you in section 161 subsection 2 also. Section 161 subsection 2 we studied about alternate directorship. There also I taught you the same point, that alternate directorship is included in this maximum directorship limit given in 165. Next is this limit exclude directorship in dormant company or section 8 company. Means you can become director in n number of dormant company. Madam, I am director in 50 dormant company. Is it okay? Yes. Doesn't matter. No limit. No limit. You can become director of any 100, even 100 dormant company. Why? Because dormant company is not working now. वो तो दिखावे की company, it's not working. So there is no compliance at all. So there is no compliance burden ना. तो कितने ही company का बन जाओ, काम तो करना नहीं है. So director can become director of any number of dormant company. This dormant company is not included in counting this limit of 20 or 10. I hope you are getting this point. Next is section 8 company, charity company na, you can become director in any number of section 8 company because that is a charity company open for all. So if you are a director in dormant company or section 8 company, then you can become n number of dormant company director or n number of section 8 company director. That will not be included in the limit of this 20 or 10. And lastly, you can reduce the limit by passing SR. You cannot increase the limit. Why? Because this is maximum limit. Law ने बोल दिया maximum, उससे ऊपर नहीं जाना, तो सोच भी नहीं सकते, लेकिन इस लिमिट को आप कम कर सकते हो. मतलब मान के चलो Reliance, let's say Reliance said that those people who are director in our company, they cannot become director in more than 5 companies. So they reduce this limit. They reduce this limit of 20 to 5. Can they do so? The answer is yes, by passing a special resolution. आपको नहीं मंजूर है, आप रिलायंस का डायरेक्टर मत बनो. आपको रिलायंस का डायरेक्टर बनना है तो फिर उसकी लिमिट फॉलो करनी पड़ेगी. सो एनी कंपनी कैन रिड्यूस दिस लिमिट बाय पासिंग स्पेशल रेजोल्यूशन. Any company can reduce this limit by passing special resolution. You can reduce the limit of this 20. So any company can say that our directors, so we won't allow. Even they can say that our directors will not become director in, let's say, more than 2 companies. Or they can say they will not become director in any other company. So they can reduce this limit by passing special resolution. Special resolution. And if you don't follow, you will get penalty of 2,000 per day, maximum 2 lakh, 2,000 per day, subject to maximum of 2 lakh. And you know what, also if you accept directorship more than 20 companies or more than 10 public companies, then you will be you will become disqualified. You will become disqualified. Remember 165, if you accept directorship in more than limit prescribed in 165, then your seat will become disqualified. Your seat will be, you will become disqualified under section 164. Remember? Yes, madam, we remember. You will become disqualified under section 164. So here's one example given. You are director in 10 private company, normal director. 5 private company, alternate director. 10 public company, normal director. Is it okay? The answer is no. Why? Because even alternate directorship is included. So you will add all these 3 and total you are director in 25 companies. So it's not allowed. So this was all about section 165. Section 165. There is a very small section, section 166, जो book में pointer में दिया हुआ है. You can study section 166 from page number 728. So I can write here 166 page 728. So there is very small section given in page number 728, section 166, which says that what are the duties of director, rights and duties of director. Very easy section, बकवास section है. Director के duties rights क्या है? एकदम easy. To act as per article, article में जैसा लिखा रहेगा वैसे ही act करना पड़ेगा. They have to do activity by complying the article. They have to act in good faith. Good faith means to promote the interest of company, employees, shareholders, to promote the object of the company for the benefit of company. to exercise due care, due diligence, skill and diligence, लापरवाही नहीं करनी है, negligence, he don't have to do negligence, he should exercise his proper care, skill, diligence, avoid conflict of interest, he should not involve in such a situation where his personal interest will conflict with the interest of the company, he should not take any undue gain, वो अपनी पर्सनल प्रॉपर्टी को कंपनी में महंगे में बेच रहा है, मतलब अपने पर्सनल एडवांटेज के लिए कंपनी को नुकसान पहुंचा रहा है, he cannot do anything for his personal profit which result into the loss of company, so he cannot use the company for attempting personal gain, undue gain. In that case, he have to refund that gain to the company, and also it will be against his duty. So he cannot, director is not eligible to achieve, he should not, a director should not achieve or attempt to achieve any undue gain for himself or his relative or his partner. If such director is found guilty of making such undue gain, he will be liable to pay the amount of the gain to the company. If अगर वो company का use करके, if you are using the company to make any personal gain and you let's say earned a personal 1 crore rupees by using the company, then you have to refund that 1 crore rupees to the company. You cannot make any undue gain. Lastly, duty not to assign office. आप अपना agent नहीं बना सकते. Director cannot appoint an agent. Why? Because director cannot assign his office. Director cannot assign his office, and if he is assigning his office, that will be void. Why? Because director is already the agent of company. एक agent सब agent नहीं बना सकता without the approval of principal agent. यहाँ बोला है director खुद agent है. Director अपना proxy नहीं appoint कर सकता. Director is also himself agent. Director cannot assign his office. Director अपनी responsibility किसी और को नहीं दे सकता. Director cannot give his responsibility to any other person. Director will be responsible for his position. He will incur liability for his mistakes. Okay, so director cannot assign his office, which means he cannot appoint agent, he cannot transfer his responsibilities, and if he is appointing such agent, that will be void, that will be null and void, that will not have any legal effect. If you are contravening section 166, you will be liable to a fine of 1 lakh to 5 lakh, between 1 lakh to 5 lakh. So this is the very small section 166. Now let's talk about section 163. सेक्शन बहुत अच्छा है, बट एग्जामिनेशन पॉइंट ऑफ व्यू के लिए एवरेज है, यू कैन से. Section 163 talks about appointment of director by proportional representation. Please let's listen to me carefully. What do you mean by proportional representation? Usually, who appoints director? Shareholders. So let's talk about Reliance. Let's say this is Reliance. And in Reliance, Mukesh Ambani has 60% shareholding. Let's say there are thousands of people, including me. Thousands of people holding this much share. So let's say all of these people together have 40% shares. So don't you think that who appoints director and how? अभी हमने पढ़ा who appoints director and how. Please tell me who appoints director. Shareholder appoints director. How they appoint? By passing ordinary resolution. What do you mean by ordinary resolution? Ordinary resolution means more than 50% approval, which means you are getting majority votes in favor, more than 50%. And don't you think that अगर रिलायंस में कौन डायरेक्टर होगा कौन नहीं, ये मुकेश अंबानी अकेला ही डिसाइड कर सकता है, क्योंकि उसके पास 60% है, वो अकेला ही और पास कर सकता है. सो हियर even if they want anyone to get appointed as director, they can't. Why? Because nobody will listen to them. Anyhow, we need a OR and they cannot pass OR. This single person can alone pass OR. So don't you think all the directors of this Reliance Industries Limited will be appointed on the wish of Mukesh Ambani. Why? Because he can alone pass OR. He has majority shareholding. So all this minority shareholders, their interest will be ignored. Nobody will be there like a Shaktiman to protect this minority shareholder. कोई तो ऐसा इनके बोर्ड रूम में होना चाहिए ना जो इनका शक्तिमान बने, जो इनके इंटरेस्ट को प्रोटेक्ट करे. There should be some Shaktiman ना, there should be some Superman who will protect this minority shareholder, who will represent this minority shareholder in the boardroom of the company. The answer is yes. That's where the concept of appointment of director by proportional representation come in, which says that if you want, you cannot follow this normal procedure. This normal procedure is like by majority vote, a director will be appointed. This is the normal procedure. However, section 163 says that you don't need to follow this normal procedure. You can appoint a director by proportional representation. And very first thing, I want to give you some important points about this section. The first important point is this section comes with a non-option clause. Non-option clause means that this section will have overriding effect over any other provision. Matlab, if you are appointing a director through proportional representation, you don't need to follow any other section. You don't need to follow any other section of this act. So this section comes with a non-option clause that notwithstanding anything contained in this act, we don't care whatever is written in any section of this act. If 163 is followed, we will follow no other section. Number two, this is optional, not compulsory, which means that the language of section 163 says a company may appoint director by proportional representation, which means it is at the option of the company. आपको करना है तो करो, नहीं करना तो मत करो. This section is not compulsory. It's not compulsory for a company to appoint a director by proportional representation. It's not compulsory. आप मुकेश अंबानी को नहीं बोल सकते, आपके नहीं सुनेंगे, इन माइनॉरिटी को डायरेक्टर अपॉइंट करने दो. So it's like it's not compulsory, it's optional. If a company want, it can follow the proportional representation process, or if it don't want, it cannot opt in 163. It can ignore section 163. So section 163 is optional and not compulsory. Section 163 is optional and not compulsory. Point number 3. This section says that you will appoint at least, this section says that as per section 163, you will appoint at least two-third of total director, by proportional representation. This section says that if you are appointing a director by proportional representation, then you should appoint at least two-thirds of the total director. Let's say total director are 10. Then two-thirds will be 10 into 2 by 3, which is basically something, I guess, 6.6667 something. So two-thirds, at least two-thirds means minimum 7. So at least two-thirds of the total director should be appointed by proportional representation. This is given in section 163. And what do you mean by proportional representation? Some methods are given. How does proportional representation work? Proportional representation has 3 methods. Number 1, by single transferable vote. Number 2, by cumulative voting. Number 3, by otherwise, by any other method, any other transparent and effective method. तो आपको सेक्शन 163 बोलता है कि आप डायरेक्टर को अपॉइंट कर सकते हो इन तीनों मेथड से. अब ये तीनों मेथड क्या होता है? वैसे तो ये एग्जामिनेशन पॉइंट ऑफ व्यू के लिए इंपॉर्टेंट नहीं है, बट एकदम शॉर्ट में मैं डिस्कस करूंगी. ये क्या होता है? सिंगल ट्रांसफरेबल वोट में क्या होता है? लेट्स से इफ वी हैव 4 सीट्स, let's say if we have seat number 1, seat number 2, seat number 3, seat number 4, and we want to appoint 4 directors, चार सीट खाली है, we want to appoint 4 directors, then हम चारों का क्या कर सकते हैं, एक साथ हम बोल सकते हैं कि अच्छा आपको usually what is the usual procedure, the usual procedure is you need at least more than 50% approval to appoint a director. Here single transferable vote says that, let's say I have 4 seat vacant, I have 4 seat vacant, I have to appoint 4 director. So what you will do, you will divide the votes, that okay, you will divide the vote 21%, 21%, 21% and 21%, which means that all the directors, let's say यहाँ पर बहुत सारे कैंडिडेट खड़े हैं, this all are the candidates, they want to become the director. So among these candidates, all those director who get 21% vote, let's say this 4 got 20% vote and this 3 got 18-19% vote, or let's say 5% vote or 10% vote, then this 4 will be appointed. तो हर वो director जिसको 21% vote मिल जाएगा वो appoint हो जाएगा. छोटी सी बात है, single transferable vote. So don't you think that अगर ये वाला method follow करेंगे तो even this people, even this चिंदी पिंदी shareholder who are holding 40%, they would be able to appoint their representative in the board? The answer is yes. वो लोग अपना एक रिप्रेजेंटेटिव तो अपॉइंट कर पाएंगे, यस, एक या दो. सो हियर वन पॉइंट इज गिवन दैट व्हाट यू मीन बाय सिंगल ट्रांसफरेबल वोट, दैट अ मिनिमम कोटा इज फिक्स्ड. अ कोटा इज फिक्स्ड, लेट्स से कोटा इज 21%. एक फॉर्मूला होता है, इस फॉर्मूले से कोटा निकालते हैं. दिस मिनिमम कोटा मीन्स मिनिमम वोट, दिस मिनिमम कोटा इज फिक्स्ड लाइक 21%. सो इन दैट केस all the directors who will get 21% vote or more than 21% vote, they will be appointed as director. So this is the method of single transferable vote. Now there is another method of cumulative voting. What does cumulative voting says that, let's say there are 4 seats. Let's say there are 4 seats, seat 1, seat 2, seat 3, seat 4, and let's say there are 10% in the candidature. Not 10, let's say this people, this many people are saying okay, we want to be appointed as the director, and but their seat are only 4. We will appoint any 4 person, in this 4 seats. We will appoint any 4 person. So we will do 4 appointments, 1 appointment, 2, 3, 4. So there is 4 seats. So now normally if I have 1 share, I get 1 vote. Now normally what is the voting procedure? If I have 1 share, I get 1 vote. So if I have 10% share, I get 10% vote. But cumulative voting में क्या होता है? What happens in cumulative voting? In cumulative voting, if you have 1 share, then you will not get 1 vote. You will get as many votes as number of seats are there. जितने seats हैं उतने vote मिलेंगे आपको हर share के लिए. मतलब कितने seats हैं? How many seats are there? 1, 2, 3, 4. 4 seats are there, means you have to appoint 4 directors, which means you will get 4 vote for every share. 4 vote for every share. Let's say you have 100 share. So how many vote you will get? You will get 4 vote for every share. So you will get 100 into 4, which means you will get 400 votes. And you know what? You will get 400 votes. So all these 400 votes you can give to even one single person. It's your wish to whom you want to give these votes. Either you can give this 400 vote to one single person, or you can divide it among the different members. So this is the method of cumulative voting. I hope this point is crystal clear to all of you. That by following this procedure of single transferable vote or cumulative voting, even in our election this method is followed. So by following this procedure of single transferable vote or cumulative voting, even the minority shareholder will be able to appoint their favorite person in the board. वो लोग अपना favorite person भी board में appoint कर पाएंगे. So by following this proportional representation method, the even minority shareholder will be able to appoint their representative in the board of director as the director of the company. Are you getting this point? और इसके अलावा आपको दोनों में से कोई मेथड पसंद नहीं आया, सिंगल ट्रांसफरेबल वोट भी पसंद नहीं आया, क्यूमुलेटिव वोटिंग भी पसंद नहीं आया, so you can adopt any other method which is transparent and effective. So all these 3 methods are known as proportional representation. Proportional representation मतलब सबको मौका मिलेगा represent करने का. We will give proportional representation. भेदभाव नहीं करेंगे, सबको बराबर का मौका मिलेगा. So this is the concept of proportional representation. However, this is optional because nobody wants the proportional representation. Obviously, like if Mukesh Ambani have the majority shareholding in the company. If he have the 60% shareholding in the company, obviously he will want that I will appoint the director, and I won't give this chindi pindi shareholder right to appoint the director. So that is why it's not compulsory, it's optional for a company to follow this proportional representation. And in order to follow this proportional representation, you have to mention this one more point, one more additional point. You have to, if you want to adopt this proportional representation, then you have to mention this in article, which means that if you want to adopt this proportional representation, then you have to alter your article, and in your article you have to write that we will appoint our directors by following the proportional representation. So this was all about section 163, which talks about proportional representation, which says that this section is not compulsory, it's optional. And once section 1 if you want to follow this 163, then you have to mention it in the article. If it is not there in your article, then 163 will not be applicable to you. So it's optional for you. If you want to follow 163, you can include such provision in your article, and which says that if you are adopting 163, then at least 2/3 of the total directors should be appointed by proportional representation method, either by single transferable vote or by cumulative voting or by any other transparent and effective manner. Lastly, non-applicability. An exception is given that this section is not applicable to 100% government company. 100% government company means such a government company in which 100% shares are held by central or state government, and subsidy of such government company. Subsidy of such government company. So I hope this point is crystal clear. And you know what? This section comes with a non-option clause, which means that if 163 is applicable, then you don't need to follow any other section. Basically, क्योंकि यहाँ 162 clash हो जाएगा ना. 162 tells about appointment of director to be voted individually, कि हर डायरेक्टर का अलग अलग वोट करोगे, एक साथ वोट नहीं कर सकते. लेकिन यहाँ तो इसमें तो साथ में ही वोट होता है ना, इसमें भी साथ में ही वोट होता है ना सारे डायरेक्टर्स का. सो बेसिकली दिस सेक्शन there is a conflict between 162 and 163. But if you are following 163, then 163 comes with a non-option clause, which means that if there is a conflict between 162 and 163, then 163 will override. 163 will have an overriding effect, and we will not follow 162, we will follow 163. So this is the small provision about 163. This comes with non-option clause, not compulsory. 2/3 of director appointed by proportional representation, by single transferable or cumulative voting. To apply this section, you have to mention in the article. That's it. We are done with section 163. We are done with section 163. And you know what? The section 170, 171, 172 is not important. It is not given in your module. Section 170 simply talks about that company has to maintain a register of all the director and KMP. Section 171 says that members have right to inspect. This register of director and KMP. And one thing I already told you. That here in 171 point is given that whenever a director or KMP is appointed or there is any change, then every time a director or KMP is appointed or there is any change or he is removed, then a company has to file a form to the ROC, that is DIR 12, within 30 days. That's it. You don't need to read this further. 172 punishment you can ignore. So we are done with this chapter. 149 to 172, all the sections done. We are done with our 149 to 172. We are done with this chapter, appointment and qualification of director, section 149 to 172. क्या आपको समझ में आ रहा है? Are you able to understand? Are you getting confidence कि हाँ 149 से 172 में केस लो आएगा तो मैं बना लूंगा या बना लूंगी? Are you getting this confidence? Are you getting this confidence? That yes madam, 149 to 172 crystal clear. Appointment of director, appointment and qualification of director, everything about director crystal clear. Are you getting this confidence? Give me a quick reply in the chat box. Yes, everybody is saying yes. Great. Should we start board meeting now or tomorrow? Then one day your class will get extended till 16th, I guess then. Okay, we'll do tomorrow. Tomorrow क्या करेंगे? Tomorrow we will study section 173, 174, 175, 176 तो इतना important है नहीं, 177, 178, 179, 180, 181, 182, 183. All this section we will do tomorrow. Basically 173 to 183 which talks about board meeting. ये तीनों section board meeting के हैं. 173, 174, 175 is for board meeting. After that 179 to 183 is for the board powers. Board powers, ये बचे कुछ section board powers के हैं. These are the sections of board powers. Board powers, and this 173 to 175 is board meeting. So we will do this two topic tomorrow, board meeting and board powers, section 173 to your section 183. Okay, so we'll complete this tomorrow, 173 to 183. I hope what we are studying is crystal clear to all of you and you are able to understand. If you have any doubt, do let me know in the Telegram, Instagram, anywhere. I'll surely try to clear your doubt. Okay, so I'll see you tomorrow in the SBC revision at 12 p.m. Till then, keep learning, because the more you learn, the more you grow, and the more you grow, the more you achieve. Take care. Bye bye.